Good morning, everybody. Can you hear me? I sound like a robot, but um, good morning. My name is Jim Owens. I'm the Fair Housing Manager of the Washington State Human Rights Commission.
And I'm Heidi Termer. I'm a Civil Rights Specialist with the Washington State Human Rights Commission.
So this morning we're going to be talking about fair housing, kind of the stuff that our agency does, and some ways that you can better inform yourselves and make sure that you don't end up with a fair housing complaint. We have a fair bit of material put together here. It is not comprehensive. It's going to be some kind of overview stuff, things for you to keep in mind. But if you have particular questions about a specific area, please raise your hand. Let's get the questions out there so that we can talk about stuff, things that you're seeing in your own practice or just questions that you have. So don't feel like you have to just sit here and listen to us talk about slides the whole time. I'd actually appreciate if you asked some questions. So I guess as just kind of a brief introduction, the Washington State Human Rights Commission is a neutral fact-finding agency. We're tasked with investigating complaints related to the Washington Law Against Discrimination and the Fair Housing Act. We do that by investigating cases. We have the authority to compel testimony, produce evidence. We have subpoena power. We can enforce it through contempt proceedings as well. We can do on-site inspections, review of records, and essentially we put together investigations that determine whether or not discrimination occurred. We also try to work to resolve cases. So we work towards settlement to see if we can come to some sort of resolution that makes both the parties feel like they've gotten a reasonable resolution, and then also work to make sure that potential discrimination doesn't happen again in the future. Cool.
All right. Thank you, Jim, for kicking us off.
Yeah.
One little tidbit, we do have some materials that we brought, so after the training is over, if you want to come up here, they're laid out on a chair because we didn't see a table spot to put them. So there's just a handful of brochures, and if you do need a pen right now and don't have one, maybe raise your hand. We've got some pens, but so moving on, we're going to talk about both federal law and state law, specifically fair housing in federal law and state law. Fair housing is a term that's pretty casual term, but really we're talking about enforcement of the Federal Fair Housing Act and the Washington Law Against Discrimination. There are a variety of agencies in the state that do this kind of work, but the agencies with the current enforcement power that apply to the state would be HUD, the United States Department of Housing and Urban Development, and our agency, the Washington State Human Rights Commission. Fair housing covers all types of housing transactions. We are going to give you some tidbits about the fair housing laws that hopefully are applicable to the work you do and help you understand some of your responsibilities under the law. But again, this is just really an overview, and like Jim said, we encourage you to go forth and get more training, delve in deeper if you haven't already, because there's so much information available about the fair housing laws that we really could fill a whole day, and we don't have that kind of time. So there are lots of free options available. You can do easy internet search for fair housing training in Washington State, and you can probably find a couple of options. Northwest Fair Housing Alliance, one of our partner groups, has some options available on their website that we recommend that you browse and see if something's useful for you.
And also, HUD has lots of information that you can use. But one thing I would say, this was actually my first manager after I got out of law school. I would come up to him with a question, and the first thing he would say was, "What does the statute say?" It is always a great reference for you. The statutes themselves, while not always super easy to read, it is the information that dictates what our authority is, what your responsibility is. And also some of those statutes actually have things like examples. Like if you look at the federal statute, so like 24 CFR Part 100, it outlines fair housing, but it also gives you especially a lot of examples about like disability related issues and kind of how those statutes are applied. So always recommend check that out first. You also have the ability to reach out to us. The Washington State Human Rights Commission provides technical guidance as well. I would say that if you have legal counsel, you should probably follow whatever protocol you have to talk to them first. But if you have a very specific issue and you're not quite sure exactly how you should address it, you can reach out to us. And if we're able to, we'll give you some guidance so that you can make sure that you stay out of trouble. All right. So fair housing covers a lot of different issues. It also covers a lot of different types of dwellings. So kind of just about everything that you can think of in terms of a dwelling is covered by the Fair Housing Act and the Washington Law Against Discrimination. And then also really like anybody that you can think of that is somehow connected to housing is also covered by the laws. So we have a lot of entities and people that reach out to us and say, hey, like we don't have to do this. It doesn't say in the law that we are particularly responsible for these things, but the Fair Housing Act and the Washington Law Against Discrimination are written pretty broadly, particularly the Washington Law Against Discrimination. And with liberal interpretation, it is possible that really any contact you have with like a real estate transaction, you're probably going to need to make sure that you know this stuff.
So the focus when we start talking about housing discrimination is on protected classes. And individuals who claim discrimination must claim it based on a protected class. And here's a nice list of protected classes. But not only do we accept complaints from people who allege discrimination because of their protected class, they also may allege discrimination because of their association with someone who is a member of a protected class. So it could be a friend that comes to visit, it could be a work colleague. If there's a connection to a protected class that's obvious and clearly connected to the housing transaction, those are the kinds of complaints we look at. Now, I'm not going to read you this whole list. I do just want to point out that there are quite a few protected classes, and that this includes both federally protected classes and Washington law protected classes. So those are all covered in one way or another by both of the laws that apply in Washington state.
Yep, and a good thing to keep in mind is if you take a look at these protected classes, it becomes pretty clear that every single person is covered by them. In some way or another, every person has the right to be protected by fair housing laws.
So true, even though if you look at me and make an observation about my race, if a housing provider didn't want to rent to me because of my race, I'm still protected.
Okay, so we want to do kind of a brief overview of what different types of discrimination look like, kind of what different treatment or disparate impact may look like. We're going to cover reasonable accommodation and modifications, harassment and retaliation. Fair warning, disability-related cases are the bulk of what we do, and so we're going to have a fair bit to cover there.
The two main types of discrimination that we look at outside of reasonable accommodation and modification denials would be different treatment and disparate impact. So different treatment is really the most common claim. And it's essentially when someone's treated differently than similar tenants or applicants or people inquiring about housing based on their protected classes. So if we have in-place tenants, we could be seeing lease violations that are issued in a discriminatory manner. An example would be giving noise violation notices to one household because they have children or because they have some other protected class, while not giving those same violations to other people of different households. Selective enforcement of the rules based on a protected class is a good example. Issuing a pay or vacate to someone instead of offering them a payment plan is a very good example. And having different terms in a rental agreement, such as higher rent or higher fees, again, this treatment would all be based on protected classes to be fair housing issue.
And And to give you kind of an example of the things that we would look for, I mean, this is, I think the easiest thing to understand is just treating people differently. But from an investigative perspective, we're going to be looking at how everybody else is treated. We're going to be looking at all the records, finding out, like, let's say that there's violation notices being issued. Are those similar violation notices being issued throughout the subject property? Can we find some sort of clear pattern in terms of how those are being issued or who they're being issued to? And we're going to compare everybody else through that subject property.
Great points. Just to break down disparate impact a little bit for you, disparate impact is when there is what appears to be a neutral policy or practice. It's neutral on its face, but the impact of enforcing that policy ends up having a stronger impact or a stricter impact on people based on their protected class. So some examples would be a housing provider refusing to accept child support or alimony payments in determining someone's financial eligibility. This would be a good example of discrimination against women and discrimination against families with children. Another example, there's a case that you can look at.
Yeah, so this is just kind of an example of things to be on the lookout for. So there's a pending case currently. It's the State v. City of Sunnyside. So this is not to say that this is law by any means yet, but something to be aware of. So the issue is that the City of Sunnyside, they had created a crime-free rental housing program, which on its face, right, served the goal of reducing crime and improving the quality of life for residents in housing. But the state has alleged that the way that it was actually applied, the way that it was enforced, was falling much more harshly on Latinx households, women-headed households, and families with minor children. Essentially, the way the program worked was that if there was a crime that was alleged to occur at a property, the landlord had a responsibility to essentially take all steps that they can to remove that tenant and seemingly remove the crime issue. But even though that may be a great goal, if you don't apply it equally to everybody and you just start enforcing it to particular types of people, then you run the risk of a lawsuit or talking to us. Cool. So these are just some examples of different treatment. I'm not going to go through all these because I think that different treatment is relatively easy to understand.
And I think this PowerPoint may be available afterwards, so you can certainly have this for your records later.
So this is where you all have to actually participate.
Yes. If you haven't had your coffee yet, quick, dash out and get a cup so you're awake.
And we have Mike ready with a mic.
Mike with the mic.
So feel free to raise your hand. We'll get you a microphone.
All right, so here's our first scenario. We're going to test out your listening skills and maybe your prior knowledge. After Toshiko, who is Asian, requests some repair work, a week goes by and no repairs have been made. They chat with other residents who are not Asian, and they learn others receive quick repairs. Is this a fair housing issue?
Ooh.
Okay, we've got a hand up. Mike, can you bring the mic?
Raise your hand.
Who wants to be on the record here?
Okay.
It could be. It depends on the circumstances. For example, if they were ordering repair parts and things like that. However, communication should have been discussed with the resident.
Great point. I think
Did
we
you
had.
read our notes?
Do we have more?
So my question would be.
Oh, will you wait for the microphone? Sorry. Thank you.
You receive a complaint like this. How would you parse out the potential discriminatory issue from the very first call that you get complaining that his repairs had not been done? How do you do that? Because from a landlord's perspective, we're wondering how you decide to, I guess, take case in
Sure.
a sense, and be able to evaluate it from one that potentially could just be him complaining it's taken too long, but again, we're
Yeah.
waiting on repair parts type of thing.
Yeah, very fair question. Hopefully everybody heard that. For us to draft a complaint on somebody's behalf and file that with our agency and file it with HUD, we just need somebody to come to us and provide us with sufficient information to support whatever that particular legal theory is. So if they're saying that they were discriminated in terms of the terms and conditions that are being applied to them, so for example, like how quickly they're getting repair work done, then they need to demonstrate that they have a protected class, that the landlord's aware of it, that some sort of adverse action is being taken against them, and that others not of their protected class are not being treated that same way. We're not going to do a full investigation before a complaint is drafted. We take that information, and if it supports a complaint, we're going to file it. It may result that once we start investigating, I think I mentioned this before, we're a neutral fact-finding agency. We don't advocate for the complainant or represent them. We're not trying to prove their case. We're trying to figure out what happened. So it may end up that when we investigate, we start getting the information from you or any other housing provider, and it starts to become clear that there's more to this. Maybe they did feel like they experienced this unnecessary delay, but maybe they didn't know the information. Maybe there wasn't communication about why there was that delay, and that's what we're going to do. So I guess that's one way to say that just because you get a complaint doesn't mean that we necessarily think that you did something wrong. It means somebody's been able to articulate enough information for us to draft that complaint, and then we'll go through and figure out, what actually happened and issue a finding.
Where do the ones go that you don't get enough information? Where do the ones...
We're going to have you repeat that
Yeah,
on the
sorry.
mic.
Where do the ones go in the universe that you don't ever follow up on? You know what I mean?
Yeah, we obviously keep records of everybody that comes to us and seeks to file a complaint, but they essentially get dead filed, if you will. They don't turn into a complaint, and we don't take any further action. We might provide resources to that person if maybe there's an issue that isn't covered by the Washington Law Against Discrimination or the Fair Housing Act, but maybe they could find some support through like civil legal aid or something like that. Maybe it's related to the Residential Landlord Tenant Act and we can't address it. So, yeah.
Great questions.
Yeah. Now I don't know if
Stuck.
it's like delay or...
There
okay,
we
there we
go.
go. All right, so next one. Samir and Quinn are a married couple that live in an apartment. Samir is a volunteer educator but does not have a paying job. Quinn works as a private consultant. Quinn is called to active duty for the U.S. Army. Samir casually mentions in passing to the housing provider that Quinn will be gone for an extended period while on active duty, and Samir will take over handling all tenancy issues. The housing provider tells Samir they have to move out since they will be unable to pay rent after Quinn is deployed. Can the housing provider do that? Thoughts? See a lot of heads shaking no. Anybody want to pipe up? No? Okay.
Let's give them the answer.
Yeah. I think that, yeah, kind of on its face, yeah, no, probably not. In Washington, there is protection for veterans and military. This one is actually a little bit interesting to me because there's also this issue of inability to pay rent, right? The landlord is saying, I'm concerned that you can't pay rent, which is, I think, a concern for all housing providers. And so, I don't know, is the statement because of their military status or is it because of rent? I'm not really sure. But what if there was a conversation and Samir told the housing provider that actually Quinn is still getting paid the whole time they're on active duty. I have access to those funds, and I'm going to be able to pay rent. And the housing provider says, no, can't do it. Like, you still need to move out. Thoughts now? See some, here we go.
I don't want it to always be me, but
Yeah.
so first thing I would take issue with is that they're not even giving the household the opportunity to pay rent, right? It's none of the landlord's business. And they are a protected class because of the military status. Also, residential landlord tenant laws changed. You have to have reason now to terminate a tenancy, and you also have to give them a proper notice period. So all of this is an issue for me.
Yeah, good point. I mean, I think that once you eliminate that issue of payment, the only thing left becomes protected class, right? It's that military status. And then, just to be clear, we don't enforce the Residential Landlord-Tenant Act. That doesn't mean that certain issues might not come to us and be something that we need to investigate if, say, there's a protection in the Residential Landlord-Tenant Act that's not being applied equally to everybody at a subject property, then that could be something that we address. Mike, we have a question all the way in the back.
Hi, thank you for this scenario. I've got 2 questions and 2 comments.
Yeah.
So my first question is, if it were just Quinn on the lease and his spouse is still there, would that make any difference? If they weren't married and Quinn were the leaseholder and Samir was not on the lease, would that make a difference? So those are my 2 questions. And then my comment is, if Quinn's now on active duty and he has a dependent because of Samir, he would be getting extra housing pay, and that's actually assured, and so that is actually a stronger sense that he would be having funds to pay the rent. So that's my comment.
Yeah.
But the first 2 questions had to do with the lease and their marital status. Thank you.
Yeah, good question. I think, I mean, I don't know. It's going to depend on the circumstances.
Yeah, I think in some ways you're veering off into landlord-tenant law questions that aren't really under our purview, but I think, Mike, did you have a question?
No, I actually, that's a great question. So under the Federal Fair Housing Act and under local fair housing, being associated with a person in a protected class can actually afford protections. So if I was associated with a person who has a military status, active military status, I actually could say, as an association to a person with a protected class, I could actually make that argument. And so thinking about fair housing is actually not just the person with the protected class, but also associated with. So that could be something regardless of whether they're on the lease or not.
Thanks, Mike.
Thank you, Mike. And in case we didn't point this out, Mike is with the Seattle Office for Civil Rights and one of our colleagues with lots and lots of fair housing knowledge.
And we'll be presenting next. So.
All right, so we're going to move into talking about fair housing as it relates to disability. And these issues are complex, and part of that comes from the fact that everybody who has a disability is a unique person, and that many disabilities are invisible. We generally review these situations on a case-by-case basis. There isn't always a prior example for us to reference. Disability complaints are a majority of the complaints that we investigate. We'll show you some stats towards the end of the training if we get there quick enough. But they do take more evaluation, and they take more attention to make sure that we're really looking at things carefully. And when we have situations where medical providers haven't communicated clearly or well about what a person's needs are, that can complicate those cases for sure. But we're going to talk about the laws that apply and some of what meets the definition of disability and kinds of questions you can and can't ask. Probably the most important tidbit I would suggest to you today, just as a best practice, is if you're a housing provider, consider, just like me as an investigator, it's not my job to diagnose someone's disability. It's my job to have proof that they have a disability. And if you're a housing provider, it's also not your job to diagnose. You just need the verification when it's needed.
Okay. So here's information about the definition of disability. There's a little bit of a difference between the Washington Law Against Discrimination and the Fair Housing Act. But I think kind of the thing to take from this, and Heidi already kind of mentioned it, is that there's a lot of obvious disabilities, but there's probably a lot more that aren't obvious. And you should not be trying to figure out the details about what their disability is. You should be trying to figure out, if they have a disability-related need, how can we accommodate that? How can we make sure that they have use and enjoyment of the property just like anybody else would?
Sorry to steal your thunder, Jim.
That's all good. Okay. So what can you ask?
Yeah, what can you ask? That's a real good question. When you're screening applicants for tenancy or for any housing-related program, you can ask whether the person meets the requirements to qualify for the program. You would ask the same questions that you ask of any applicant to your housing or your program. If you have housing that is specifically designed to house individuals with disabilities through some sort of federal program, usually, you may ask applicants if they have the qualifying type of disability. That's really where your inquiry would end. If you run this type of program, I suspect you're already well educated about it and know about how you screen folks. If a potential tenant who is applying to your housing or program is asking for reasonable accommodations, you do have the ability to request verification that they have a disability and that there is a link between their disability and the accommodation or modification they're asking for. Again, I'll just circle back and remind you, any question you would ask of any applicant needs to be the same question you'd ask of every applicant.
So we kind of covered this a little bit already, but what can't you ask? Asking if anybody has a disability and what the nature and severity of that disability is. Those are questions you're going to stay away from.
And reasonable accommodation. This is a big chunk of the complaints we investigate. This is the complicated set of cases for us. Reasonable accommodation is when a housing provider or a program makes exceptions in their rules, policies, practices, or the way that services are provided. And the goal here is to make housing accessible to everyone, and particularly making flexing on these policies, practices, etc., can offer equal opportunity for people with disabilities. It's a pretty broad concept. There are many ways that a person with a disability might need to be accommodated. Every situation is going to have different circumstances, and you could have a tenant who over time has changes in needs, and their circumstances could be changing, and what they ask for could change. You have to consider reasonable accommodation requests that will enable them to have equal access to housing. And it could be not only their dwelling unit, but common areas on the property. Anyone in the audience review a reasonable accommodation or have granted one to someone? Yeah? Is this a new concept for anyone here in the audience today? Great, that's what we like. We like to know that everybody's had some exposure to these concepts. Some examples of reasonable accommodations that are pretty common: reserved or accessible parking spaces, assistance animals in housing that doesn't permit pets, because assistance animals aren't pets. I'm getting too deep into that. Providing information in an alternative format is another great example of a reasonable accommodation. We have a question, Mike? Maybe I can get there faster. Watch this. Oh, we're gonna race.
I need to get my steps in.
Okay, I'll let
Do you
you.
want me to hold it or you hold it? Okay. I work for the city of Bellingham, and as our requirement from HUD, we're further fair housing. I put on a presentation for landlords every year about fair housing, and we were explaining about reasonable accommodation and how it's reasonable. I mean, just treat everybody the same and nice, and it's a reasonable thing. One of the people in the audience said she had a small apartment building. A woman applied. She said, I need a reasonable accommodation for my service dog, who the lady said, no problem. I need your letter from your healthcare professional. She handed her an online form letter The landlord said, okay, this is what I need, but I would prefer if you could find a local provider to get that for me. It never came up again. The landlord did not follow through on that and ask her to leave. She lived there for 1.5 years. She moved out, and a year after she moved out, the landlord was, I'm not sure of the terminology here, but sued or approached by the Attorney General, and it cost her $70,000 because she made the tenant uncomfortable by asking, and I'm taking this all with a grain of salt, but she was the first person. There were 2 people in our small audience that had had the exact same thing happen. So it took the wind right out of my reasonable accommodations, and I'm not sure how to approach it in the future.
Yeah. So I think maybe the first thing to address, which is actually a very common thing that we see, a lot of complaints come up related to this. Emotional support animals, service animals, people providing documentation from online resources, and housing providers kind of just this knee-jerk reaction that that's not legit. And that's unfortunate. It's also unfortunate that the Fair Housing Act and the Washington Law Against Discrimination doesn't create a specific set of guidelines for what qualifies as appropriate documentation. I can't tell you there's a specific certification or something like that. And so that's why we were saying it's always this case-by-case basis. We have to look at the facts. But I would say that just because you get something that is supposedly online doesn't mean it's not sufficient. I myself had a case that I investigated where I followed up with the person that wrote that letter. I had quite the conversation with them, and they went through all of their notes and explained how they had been meeting with this person for an entire year. Really got to know them, got to know all of their medical records, understanding their needs, and did not immediately give them this letter for an emotional support animal. Didn't actually give it to them until they felt that they were in a position to actually say that it was appropriate. And in that case, the tenant had brought that letter to their housing provider, and they said, nope, you need to get one from a local doctor. So it behooves you to not distrust people. It behooves you to try to help them get the help that they need, accommodate them. And it's fine for you to do your due diligence. You can go too far. You can ask for too many things. You can start making burdensome requirements on people when they're already presenting you with the information that you need. But if you contact a health provider or some other qualified individual who knows enough about this person to say that this is a disability-related need that they have, then you should be granting that accommodation.
I don't know the wording specifically, but in the DOJ letter, the HUD DOJ letter, there's lots of discussion about the online certifications, and I think isn't the crux of it the person who is providing that verification needs to have knowledge and experience with this person's disability to make an informed decision. So it's not just you go on Amazon and you order a service animal vest
Sure.
and call it good,
Yep.
type of thing. So I think that's the problem is that person is probably providing something that you said she had a year of experience being diagnosed by this out of state, potentially online, remote Zoom provider, and that was sufficient. She thought it would be according to the law, but all that information didn't get passed down to the person who was making that decision. Like you said, they made a knee-jerk reaction. So
I think that's a real good point, and I strongly recommend, thanks for bringing up the guidance. I was thinking about it, but there's guidance out by HUD and the Department of Justice that can walk you through evaluating the situations that come up involving service and emotional support animals, or assistance animals is the kind of general term I use to blanket cover them all. And it's good to look at that and learn more about it.
HUD also has an interactive online tool that walks you through steps, if this and this type of stuff. So there are resources out there.
I think we better pick up the pace a little here.
I mean, discussion's good.
Yeah.
Okay. I don't think that we covered this, but just to kind of let you know that reasonable accommodations could come up like throughout the lifespan of a tenancy, including during unlawful detainer eviction proceedings, and even after. Reasonable accommodation is also potentially a defense to eviction. So certainly another reason for you to do your due diligence and make sure that you're handling those appropriately.
All right. Let's just talk a little bit about the process. It's pretty straightforward, really, as far as how it flows or should flow. An accommodation request or modification request is made. It could be verbally made. It could be made in writing, email, tenant portal, you name it. We hope they're not sending them with carrier pigeon. That's a little hard to document, but the next step is generally interactive dialogue. It's a back and forth process. Best practice for a housing provider or program providing housing services is not to just say no, but to engage in some dialogue. And you can request third-party verification of the presence of the disability and the need for the specific request.
If necessary.
If it's necessary. I was just wondering if we're addressing this later. I'll just address it now. If a person comes in and they are using a wheelchair, if you ask them for verification of their need for the installation of a ramp, that's not a best practice. Okay, so some things you can readily observe and the link is obvious. So please don't create extra burdensome steps by sending someone to get that letter when it's not necessary. If you ever run into a situation where you're just not sure if it's something you should ask for or not, call our agency and we can talk it out. I like to get those calls. I think it's interesting. It makes my brain work hard. So give me a call.
And I think it is important to point out at the top there that there are no form requirements, and there shouldn't be. It's totally fine to have your process in place, have a policy outlined in terms of how you're going to address reasonable accommodations. Have forms that that people can fill out to give you the information that you need, but you can't require that. You can't turn somebody away because they're failing to fill out that form. There could be a number of reasons why it might be difficult for that person to fill out that form, and they may be providing you exactly what you need in other ways. So we see that frequently. I know there's this like instinct to say, well, if we just follow the process and do it with everybody, we'll be fine. Doesn't quite work that way. You need to be able to accept reasonable accommodation requests in any form that they show up.
And being flexible on your process is another way you're accommodating persons with disabilities. But the goal ultimately is to come up with an effective solution that meets the applicant's or tenant's needs and that you're able to provide.
So I feel like we kind of have already covered a fair bit of this.
Yeah.
But one thing that we haven't covered, the things at the bottom, those are essentially reasons why a housing provider may be able to deny a reasonable accommodation request. So if it imposes an undue burden on the landlord, so that is some sort of unreasonable financial and administrative cost. If it's a fundamental alteration to the business, so what they're asking you to do is just totally outside the realm of what you do as a housing provider and what you provide to all your other tenants. Or if the tenant poses a risk of harm to persons or property. I think we have a question out there, Mike.
I'm sorry, can you wait for the mic so everyone can hear your question?
Is an undue burden, how, because I mean, is that a very vague, like how can, like a landlord can say, oh no, I don't have the finances to do that. It's a burden on me. How, is there any regulations or anything around that undue burden piece?
Well, there aren't specific regulations to establish specifically what an undue financial or administrative burden looks like. That's really a conversation with your investigator if the complaint is filed, and then we would generally ask you to document what you're holding out as your defense to why you didn't provide it. If someone's asking for a repair to a seriously broken down elevator that's going to cost, upwards of $50,000, and you can demonstrate what your budget looks like, we may agree with you that that was just something that was outside of your financial ability. But then we're going to say, okay, so what was the next step when you told the tenant on the third floor, I'm sorry, I can't repair this elevator? Where did the conversation go from there? Was it just a no, or was it, okay, what's our next possible solution?
Yeah, and that also raises the point that an undue burden for one housing provider may not be an undue burden for another. That elevator repair for a small housing provider that doesn't have a lot of resources is not the same for a national company that has thousands of property and millions and billions of dollars. So I think there's another question.
Our company as a policy is that we do not deny reasonable accommodations and modifications, but we come up with alternative solutions as much as possible. Our properties have a list of agencies that will help pay for things if there is a financial burden to the property. So that's a really good suggestion. You can Google it in your area. There's tons of agencies that will help with modification costs.
I love this.
Yeah, no, that's fantastic. It kind of brings to mind, we had a case where a person had a lot of belongings in their unit, too many belongings, and it was creating issues. And they asked for a reasonable accommodation to have more time than, say, like the correction letter that they received. They asked for more time to be able to fix that, or they asked for the housing provider to provide like maintenance people to come clean up for them. That wasn't necessarily something that the housing provider does for anybody else. But what they did do was they actually connected that person with volunteers who come in and specifically do those kind of things. They help clean the house and make sure that it's in a safe, livable condition and not creating any hazards for anybody else. So it's a fantastic way to look at it. I think you should always be trying to grant the reasonable accommodation when you can, but if you can't, then you're figuring out through discussion, okay, since we can't do this, how else can we meet this need? What's the best way to do that?
All right.
Do you want to take any more questions? It's up to you.
I mean, I'm more interested in like answering the questions you have, so I'm happy with it, but.
So in Seattle, we often have brand new buildings that have like a button to open a door for ADA accessibility at the main entrance, but it's not typically required by code to add these things to like the rooftop deck or a laundry room or a trash room. And so we are often facing, moving folks in who are wheelchair bound and these kind of questions of, okay, is this a modification? Are we required to pay for it? At what point do you guys, am I wrong that certain modifications, if an unreasonable burden, might be charged to the resident if, say, who has the means to afford ADA accessibility adds to different areas of the property, but how do you really approach that from a complaint perspective if it's, say, a smaller building or a smaller organization that may struggle to find the finances to fund these types of things? They're not required by code, but clearly at the initial move-in process, we're often running into this.
Well, I think the first step really is thank you for the jazz hands, Eric. The first step is deciding whether it's a reasonable accommodation or a reasonable modification, because if it's an accommodation, then generally it's the housing provider's burden to bear that expense. I think we have reasonable modification further on.
Yep.
So when we start looking at reasonable modifications, generally it is the tenant's burden to pay for them. The exception, of course, is if a property receives federal funding, and that would be direct federal funding to the property. We're not talking about Section 8 housing choice vouchers. Those do not make the unit a federally funded unit in that aspect.
Not like a police subsidy, but like subsidy acquisition or construction.
So a tax credit property is what you're asking related to. Okay. Tax credit property generally aren't considered to be directly federally funded. They get some tax benefits, but that's different. When a property is federally funded, they should already know that they have to set up a certain portion of their budget to cover reasonable modifications to the property. So if you aren't in a place where you've got that budget with that portion set up, then you know that that's not the federally funded burden for you to pay for those modifications. So now when you start talking about changes to common areas, it's going to benefit more than just the individual. It's going to benefit other people as well. It's really a case-by-case basis, but
Yeah, I guess to get into your question of like who's covering these changes, how are we making this, that it is case by case. We're going to have to determine whether or not it's reasonable for that housing provider, if it's a reasonable accommodation. We're also going to determine, are there alternatives, right? I mean, if it's not reasonable, are there alternatives that we could come up with other than making, expensive changes or things like that? So there's a lot that goes into considering, what's appropriate in a given circumstance. Cool. If everybody's ready, I guess we'll start talking about assistance animals.
yeah, let's talk about animals.
Cool.
I forget whose turn it is, yours or mine.
Go for it.
I'll keep talking. Animals. Some of us love them, some of us don't. They are a reasonable accommodation when they are related to someone's disability. In Washington State, it includes any kind of assistance, support, service, comfort. There is not a requirement under Washington State law for training from a school or any particular kind of certification. Housing providers need to waive policies that relate to pets. They don't have to waive policies that relate to behavior of occupants. There can be assistance animal addendums that hold the animal to the same kinds of rules as other household occupants.
So in Washington, service animal is defined as any dog or miniature horse individually trained to do work or perform tasks for the benefit of an individual with a disability. Even the tenant themselves could provide that training. Emotional support animals don't need to be trained. Good thing to keep in mind, no deposits, no pet fees, no extra charges. They are not considered pets. They're essentially an extension of the person. Cool. And I think we already kind of covered all this stuff.
Yeah, I think.
Let us know if you want to go through more details about exactly what reasonable modifications are. Another thing that kind of tangentially I think you brought up, there are some requirements under the Fair Housing Act in terms of like design of buildings. We're not going to get into that. It is pretty complex. There's a lot of information. There's a 300-page manual for you to review if you have any questions. But I will say that if you read like the first 10 pages of it, it's actually incredibly informative. It has diagrams and really clear explanations of what is a covered dwelling. So it's pretty easy to understand whether or not you fall into that situation where you need to be aware about what those design obligations are.
And that does apply to, thank you, Eric, 10 minutes left. That does apply to newer multifamily construction. So
Yep.
March 13th, 1991 or later. We have a question.
So with new construction, often there's contradictory codes around ADA and fair housing. Do you all support helping define those? And when there are safe harbors identified, are they really a safe harbor? You know, our goal is always to make everything as accessible as possible, but sometimes there's just contradictions.
When it comes to the design and construction requirements, I would really suggest you consult with HUD about that, because that's their specialty.
And there's private entities that you can consult with that will provide you guidance. We're not really in a position to be able to tell you to compare all of the different statutes that we don't enforce and tell you how you should act. So there's certain things that we can provide technical guidance on. That one's just a little bit too much for us to be able to give you feedback.
HUD does have a great resource. Accessibility First is online, and so there's a lot of thank you. I don't know how I was projecting there. HUD has a great resource, a web page on its Accessibility First program, and there's a lot of great information there and classes that you can take as well about complying with ADA and the Fair Housing Act.
Thank you, Marley. We have another question.
I'm so sorry. You can't go by animals and not get another animal question. I was wondering if you could speak to multiple animals. We often get requests for like multiple. We've got 3 bunnies and a dog and a cat and a tarantula in a studio apartment. And like I've heard some guidance that each animal has to perform a different task, but then I've heard that's not true. And then I also don't want to get in trouble for asking too many questions about all the animals. And then like what's reasonable in a 300 square foot
Let's see if I can answer this real quickly. The first thing that you can look to is what is the applicable code. If it's in the city limits or the county, you look at the code, because you can follow that code, and a person who's asking you to allow more animals or different kinds of animals than the code permits is asking you to allow them to violate the law. So you can look at the code. The second thing is, yes, the housing provider can ask for a letter explaining why multiple animals are needed. And you don't have to let someone have 17 cats in a studio apartment. And
generally whatever qualified third party is providing that information is going to need to demonstrate each individual animal's whatever it is that they are providing for that person. So there needs to be a distinct need, but that should be able to be articulated by some qualified third person.
Great.
So we have scenarios, or we have more slides, and we've only got about 7 minutes left.
Because we talk a lot.
So unless people want to go through like reasonable accommodation and disability related scenarios and kind of walk through those, we'll just kind of move on. Cool. Okay. Okay, so we want to cover harassment. Harassment in housing could be based on any type of protected class. And essentially, we're talking about unwelcome or offensive behavior due to the protected class. What we're looking for in an investigation was the behavior sufficiently severe or pervasive? Was the housing provider aware of it? And then did they fail to act?
So, of course, we've all heard about sexual harassment in some form or another. These are just some examples of overt harassment versus a hostile environment. So obviously being real overt and quid pro quo, I'll trade you rent for favors or a date, that's pretty overt. But you can also have sexual harassment in situations where the rules are applied differently in order to maybe push a woman to go out on a date, or you could have notices issued in ways that single someone out because they wouldn't go out on a date with you.
Yeah, multiple violation notices and kind of this continuing use of, the resources a housing provider might have, and imposing that upon somebody could create a hostile environment. Okay, so avoiding harassment complaints. Certainly having a clear 5 minutes, thank you. Sorry, thought you had a question. Certainly having a clear anti-harassment policy and explaining that to anybody that you employ is paramount. Communicating your policies to tenants and to staff, making sure that everybody knows how to make use of that policy. Certainly if things rise to the level of criminal conduct, you should be contacting 911. But you should be conducting an investigation. So if people are bringing you issues saying that they are being harassed, you need to figure out what's going on. We see a lot of housing providers kind of throw their hands up and say, like, this is a tenant issue. This is amongst yourselves. You need to sort it out. You have more responsibility than that. And so conducting an information, documenting all the information that you're being provided. And if somebody is harassing another tenant because of their protected class, you need to take corrective action. Same kind of corrective action that you would take with anybody else that's violating the lease or whatever rules that you have. You need to consistently be utilizing those resources and enforcing your rules.
And communicating to the person who complained whether or not you can tell them what action you're taking, at least keep them in the loop so they know that you've taken it seriously, because that's what leads to us getting complaints, is when housing providers don't communicate that they are taking action.
So I think this probably actually is a good scenario for us to cover. So Blake and Scout hang a pride flag on the outside of their apartment door. The door and flag are vandalized with comments about their sexual orientation. Scout reports it to the owner of the multi-unit building. The owner says they can't do anything, and Blake and Scout need to deal with it on their own by calling the police. This happens 3 more times, and each time Scout reports it to the owner. Is there anything the owner could or should do in response? Thoughts about how to handle that? Raise a hand. See if we get anyone.
We have a volunteer up here, Mike.
Oh, I was looking back there.
I think the hard thing is to go ahead and let everybody know that there's been vandalism happening at the property. However, I have tried that, and ultimately I've gotten some backlash that now the people who were being vandalized are being singled out by other people because they knew it was all about them. So it's a play between trying to just give everybody the heads up, stop the vandalism. I wouldn't put in stop vandalizing pride flags because
Sure.
but just there's been reports of vandalism and that sort of thing, and then having it potentially made worse because of that.
A best practice might be to include in your notice that taking any negative action against the person who experienced the harassment would be compounding the harassment, and that you may have to look at some lease enforcement if that happens.
Also, in a multi-unit building, there are potentially a lot of people who are seeing what's going on. So asking people what they're seeing, finding out if you can identify where this is coming from. A lot of people have Ring doorbell cams and other ways to record potentially what's been going on. If you're seeking out that information and trying to identify who's doing this so that you can then issue a violation notice, you can then do whatever it is that you need to do to protect this tenant and make sure that this other person is following all the rules of your property, then you're probably doing what you need to do. But if you're sitting back and saying, well, I'm not going to be able to figure out who did this, then you're probably going to run into some trouble.
We're basically at 1 minute now.
Okay. So we're almost done. We'll just real quickly. I guess this is all to say that if you have questions, you can ask us after. And like I said, you're always welcome to reach out for technical guidance, talk to Marley about training.
Keep written records, document things, communicate clearly and appropriately about the problems that come up. Here's those trends I mentioned. As you can see, over the last 10 years, disability has been the biggest protected class-based complaint filing reason.
Yep.
And over the last year, same.
Yeah.
So, a lot of information. We could have gone for a whole day about these topics.
Yeah.
Thank you very
Thanks,
much.
everybody. Appreciate you.